Hello to everyone out there. This is Contract B. This is week 10, and we are looking at misleading or deceptive conduct. Just when you thought you'd had enough misleading or deceptive conduct, it comes back. Yeah, I'll be back. You should all be relative experts in the ACL by now. Those submissions, people, loved them across the board. By and large, good job. Pat yourself on the back. Hey, Tim, how you going? So, you know, it's a bit of kickback and cruise tonight, I guess, and because you folks should be so intimately aware with the, with all, basically, be aware of all of the relevant provisions of the ACL, because pretty much most of them were discussed in the assignment. I can take a back seat and be very Socratic this evening. So, you know, I can get you guys to do the bulk of the work here, because it won't really involve much extra reading at all. This week, I think we not only looked at Australian consumer law, but we also had a little look at equitable remedies. And we also had a little look at restitution, if I'm not mistaken. So, you know, if you wish to discuss that stuff, I mean, there is more questions on the ACL tonight because, well, A, we need to hammer that stuff home, but B, it was fairly evident from some of the assignments that they hadn't gone and looked at the remedies provisions of the ACL, and you know, everyone knows about the usual suspects in terms of sections of the ACL that we need to know about, but a lot of people haven't turned their minds to the remedies that are connected with actions under the ACL, and there was very few students. There were some, and they're in this class, well done, who actually cited the provision in the legislation that deals with the ability to rescind for a breach of the misleading or deceptive conduct provision. And I thought that was outstanding attention to detail, so that was great. Keith, you're here. I think you're the one assignment I haven't yet marked. That wasn't intentional.
I got that.
I will do that after class tonight. You'll have your marks this evening along with everybody else, so don't you worry about that. I was just saying everyone has done very, very well, very happy, you know, by and large across the board. But a lot of people do not plug in a discussion of how rescission would fit into the ACL. So I'm hoping that save the best for last. So I'm hoping that this might kind of close the loop for some people that didn't really turn their mind to this issue when they were looking at the assignment. I have been asked previously, you know, why do you take such a focus on the ACL? And my response to that is, generally speaking, well, A, we have to cover it in terms of, you know, accreditation stuff, but it doesn't have to be done in contract law. And I would be interested to get some of your thoughts on this moving forward, because I don't know whether any of you people, there is an elective, I think, on competition law. Is there not? Have you seen? Yeah, there is. I don't know if that covers off this stuff, misleading or deceptive conduct. I know that, there's not a whole lot of discussion of the ACL in some texts on contract law. So I would just, at the end of the unit, actually when you're doing your have your saves, can you let me have your thoughts on the ACL components of contract A? If so, remember that was the consumer guarantees and the unfair contract term stuff. Just let me have your thoughts on this, because as a practitioner, I know the value of this stuff. Like, it is, Section 18 is so incredibly handy, not just in terms of contract law, but for anybody that is doing IP law with me next term, you will see that in terms of even trademark law, Section 18 comes in really super handy. So it's not actually just in terms of contract, it is in terms of a lot of different areas of law that Section 18 comes in handy. So, and the value, one of the reasons why I get you to go back and look at this problem with, Rocco and whatever her name is, with the seafood supply, these are the bread and butter kind of situations that you often come across in practice. And you will recall that when we had a look at that problem, like earlier in term, we looked at it in terms of misrepresentation. And we saw just how hard it is to try and prove misrepresentation at common law. And we saw the nooks and crannies and twists and turns and frustrating elements that you have to prove. Particularly difficult was this issue of intention. And Section 18 is just like the practitioner's dream, because even if you're going to run a common law argument of something like misrepresentation, and it does crop up in, trademark law occasionally. Yep, you got it, Tim. You will always, always, always run a Section 18 argument in parallel, because it's just so much easier to work with, so much easier to satisfy, and it can be used by business as much as it can be used by the consumer. It was originally obviously drafted for the consumer, but it has become a real weapon in the hands of small business. And that's why I do tend to take a significant focus on the ACL. But I would appreciate your thoughts anyway. When you do your have your says, I won't say if, when you do your have your says, can you let me know about that aspect of the course? Because I'd be quite interested to see, from a law student's point of view, whether you can see the value in it or not, whether I've demonstrated to you its use and its usefulness. Cool. So without further ado, what I might do is just share my whole messy mind again. Pardon my messy mind. So there we go. The old girl's working. All right. I'm going to put that there. It's hilarious. I just, I started using a PC instead of a Mac. Ooh, and isn't that fun? And my computer now knows that I go to the ACL so often. It's put it in my shortcuts without me even having to ask. It's just there. So I've put up this thought food for you to have a look at. Did you want to go and have another little look at the tutorial problem, or was that's a nod? Okay, we'll go and have a little look at Here we are. I think that's the wrong term. No, it's not. Where are we? Oh, down here. There we go.
Rocco, please come in. How's business? You still make the best pasta in town, you know.
Hey, thanks a lot. You should come back into the restaurant soon. I let the chef make you something special.
You know, I'd really like that. But in any event, welcome to my shop. What can I help you with?
It's a bit embarrassing. I've been pretty foolish, I think.
You know everything you tell me here is confidential.
Okay, you remember Maria?
The waitress in the restaurant. She was lovely.
Yeah, I thought so too. In fact, once she began working for me, I started to feel pretty strongly about Maria. I guess I started pursuing her. You know, romantically.
I understand. How did that go?
Not too well. She wasn't real interested at first, and I wasn't sure how hard to push. You know, being her boss and all. I didn't want to have to come see you about a sexual harassment claim.
That's very wise.
Anyways, eventually she seemed to come round. We went on a few dates, had a few laughs, maybe a couple of overnight stays. You get the picture?
Sure.
As things progressed, I was like a teenager all over again. Daydreaming about her, distracted at work, trying to make little romantic gestures all the time. It was nice. She wasn't really doing the same in return, but some girls are like that. I thought things were going nicely.
Were they?
Well, there was this big incident. Maria came to see me and said she was in trouble. She used to date this slime called Ed. Ed was involved with drugs. And now the drug pushers were after Maria for 30 grand, which they said Ed had borrowed. If they didn't get it, they threatened to burn Maria's house down. Obviously, Maria didn't have that sort of money. She came to me for advice.
What advice did you give her?
Well, I told her I would lend her the 30 grand and that she should pay it to the men and then immediately afterwards go to the police.
That's extraordinarily generous.
Yeah, but I thought I was in love. And there was something kind of cool about coming to the rescue of a damsel in distress. You know? Kind of like a gentleman.
Did you give her the money?
Loaned it to her. Yeah.
Do you think she will see it as a loan?
Oh, yeah. We signed a piece of paper saying so. I didn't really want to. I didn't really expect to ever see the money again. But she insisted that she wouldn't take charity and made me sign.
Did she take the loan money and pay the drug dealers?
That's where the whole story gets a bit crazy. Next thing I know, you see, she's driving around in a new car. She never brings it to work, but I've seen her around town in it. And I hear one of the other waitresses saying that she's just bought a new laptop computer and a new TV set and got pay TV connected. I'm not sure there were any drug dealers at all. I asked Maria about this, and she broke off our relationship saying I didn't trust her. Damn right I don't trust her now.
That's probably a fair call. What do you want to do?
What do you think? I want my money back. Can you help me?
I'll certainly do my best.
Okay. So, let me just get my little, where's that? Oh, I think I have to put it down. There we go. Okay, so looking at, let me just get rid of this one. There we go. Okay. So, looking back at that, now if you recall, let me just get your faces over here so I can talk to you. There we go. So if you recall, oh, I didn't put it here. I can bring it over here and show you. Now, there's my answers. I just want to see if I put, there we go. Here's the IRAC that we did at the beginning of term. and we had to look at fraudulent misrepresentation. We had a look at Dairying Pig, and we stepped through all of the elements. Fraudulent misrep. Also, you need to be proving, obviously, intent. And then we went ahead and we looked at the case law there that said, you know, it's very difficult to show the whole element of intent. Okay, so that was what we did before. Now I'll take that one away. What's the immediate difficulty of Rocco trying to sue under Section 18 of the ACL? Hopefully that
He's
one.
not acting in trade or commerce.
Yes, yes. So the provision, sorry, I'm just going to get into the chats here because chats are going off. Yes, Maria's not in trade or commerce. Keith says that as well. Yes, so if we get our little ACL up here, let's flick to, I reckon I could just about recite this stuff in my sleep. I reckon you could too, almost. All right. Person. But when does, and this will probe a little bit of revision, this will probe how much you know about the reach of the Commonwealth legislation. When can you catch a natural person like Maria under the Commonwealth legislation? Because I know that you can catch them under the state legislation. Yes, Keith jumped in there. If their trade involves crossing state boundaries. So remember, the Constitution has to provide the federal government with, the federal parliament with the ability to legislate in this area. And remember that to create this legislation, they relied on the corporation's power in Section 5120. But there are other constitutional heads of power that the federal parliament can rely on to expand the reach of the Competition and Consumer Act where appropriate. And some of those other heads of constitutional power, thank you, international trade, crossing state boundaries. And the other big one is the power of federal parliament to legislate on telephone, telegraph, TV and radio broadcast and postal service. Okay, but we don't have any of that conduct here, do we? Because it's face-to-face and she's, you know, not otherwise a corporation. So that'd pretty much knock out the ACL straight away. So there's your big issue there. Where are we? Okay, could you sue under Section 18 if the misrepresentation was between two offices of two charitable institutions? This is like Jeopardy, isn't it? I'll take charitable institutions for $25.
I think yes.
Who says yes?
I'll take the yes.
You'll take the yes? Yeah, you're
I'm
right.
just guessing.
Yeah, you're right. You're right. Absolutely. Section 4, the definition of trade or commerce. I'll put the answers here because it's far more satisfying, isn't it? The definition of trade or commerce in section 4 recognises businesses or professions, whether or not for profit. What's the issue with employers and employees?
Oh, sorry. Whether the employee is acting on behalf of the employer in the representations that's being made.
I'm thinking of employees wanting to allege misleading or deceptive conduct on behalf of their employers.
Okay, sorry, I misunderstood.
Rather than, yes, you went down the vicarious liability path. Yeah, that was good though. Very sharp. And Diane, what section is that?
Yucko. Let me get back to you on that one.
139B. Yeah. Employer, employee. With that kind of communication, it will be here. Let me just pop this in here. That will normally fall outside of section 18 because it'll be held to be in relation to trade or commerce, not in trade or commerce. Okay? What they don't want is a whole heap of dissatisfied employees winding up in the federal court. There's specific employment legislation that's there for a reason. Okay. All right. As opposed to Rocco and Maria, what if the conduct involved silence? In relation to the common law, and this is where I'm about to demonstrate the beauty and the power of, I'll just put those two thoughts. In relation to silence under the common law, it's messy. Oh, Tyler's saying something. It'd be harder for Rocco to win. In the common law, a positive act is needed to prove. Yeah. There's only, yes, Tyler, there's only a very limited range of conduct, isn't there, that's available to you in terms of silence. Has to be a half-truth. Is this ringing bells? Or if there's been this statement that later becomes false, or you have this duty of disclosure. Yeah, Tim, yes. So provisions relating to section 4.2, can anyone yell those out for me? Anyone? Ferris Bueller? Section 4.2. And we have that reasonable expectation test, remember, from Miller. If you can reasonably expect that the information you are complaining of that wasn't revealed to you, if given the circumstances you could reasonably expect it to be disclosed, then it should have been disclosed. Easy peasy. Can you see how it just streamlines everything? into just nice, neat, bite-sized chunks for us. Silence is defined, or is brought, swept in, should I say, by a 4-2. Refusing to do an act, okay, failing is refusing to do, okay. Assuming for a moment Rocco could sue, statements of intent. Ooh, this should be ringing bells. This should be ringing bells. Intent is not relevant, Tyler. That's my view, Tyler. That's not everybody's view, surprisingly enough. It's not Wilmot's view. What does Wilmot say? I'm not convinced Wilmot's right, by the way.
I thought Wilmot actually agreed that intent's not relevant to ACL.
If you look at, if you have your text with you, Keith, turn with me, if you will, to 13.17 on page 531.
I'll just get one I prepared earlier.
That's it. That's it. So it says intent is not an element of ACL section 18 on page 531. And then you flip over and it says there are certain exceptions to the general proposition that intention is not a requirement. Number one, where the conduct is characterised as a statement of opinion or intention or concerns some future matter, and this is where I think they're on dodgy ground here, then the statement will not be misleading unless it's proved that the statement maker had made the statement dishonestly, recklessly, or without believing it's true. But if you look at other texts, I particularly like Cheshire and Fivefoot, and I go into an extended discussion of this whole point in my answer guide for your assignment. I can't see, and the cases that Wilmot rely on for this proposition are cases that were decided prior to the introduction of the presumption in 4.2, in section 4, sorry. So I don't know how they are. I think it's just one of those hangovers. You know, there's law that persisted prior to the introduction of this presumption. Have a look and see what you think on Wilmot's take on this. Personally, I prefer Cheshire and Fivefoot. Cheshire and Fivefoot say the whole gist of this legislation is not to require intention. The only possible way you could bring intention into it would be specifically if the allegation that you're claiming to be misleading was actually couched in terms of, you know what, I think X, or it's my opinion that X. And it's only because of the specific wording of those types of representation as being a representation directly related to the representor's state of mind that state of mind will come into it. What paragraph was that? Oh, 13.17, Diane. I don't really agree with it. I have to be really frank and honest. And what I might do is I'll take you to, oh my goodness, that's contract A. I'll take that over here. All right. I was going to just cut and paste it for you, but I won't worry. I'll do it after because it's not directly relevant here. But Cheshire and Fivefoot do question that. I'll put this back here now. We can discuss that at the end of the class if you wish. Okay, so I'll just put here. I'll put the answer guide up later. All right, so a variation of the problem, if we were going to slot it into an ACL kind of scenario. Say that Rocco owns a restaurant. Maria is also a company, so she falls now within the ACL. He says that he needs a regular supply of lobsters. She says that she's going to require further funds to establish the supply chain infrastructure to meet his supply requirements. He says he really wants her to be a supplier. Okay, fair enough. He's going to give her 30 grand for this infrastructure expansion. Again, like the problem, you know, they agree on a loan contract, payment terms and so on. She takes the money and uses it on other stuff. A massive party she streams live on Facebook, which he sees and is furious because all the other seafood owners in town are there. As a result of the loan agreement, Rocco was not able to take up the offer by a commercial kitchenware company to purchase a bulk lot of tablecloths and cutlery, which would have saved him $8,000. Okay. How would we pull this apart? Because this is going to be pretty easy for you lot, hopefully. We have,
Well,
what does he want?
wants his money back.
Hmm.
Oh,
So we're assuming that he wants to rescind the agreement and obtain his money back.
And ideally, part of the loss from not being able to take the other contract.
Yes. Why don't you think about that and tell me if you can get that, Keith?
No, it's too remote. If it was a normal contract, okay. I can't remember the name of the case, but there was a case that said if it was a super duper contract, no, you couldn't be reimbursed for that. That was the connection was just the causal link was just too great, too distant.
Lost opportunity.
Yeah, lost opportunity, but causal link.
Yeah, because he didn't have the cash because he had used his cash to pay Maria, which he would have had if he didn't have this contract.
But doesn't the contract have a super profit to it rather than just a normal profit to it?
What? How is that relevant to an issue of lost expectation? We'll get to that down the track, Keith.
Okay. Well, I'm obviously on a tangent that I missed the points to come back to the normal line.
It's 10 to 8. We're nearly home. Okay, contract for breach of Section 18 by Maria's company. Okay, Rocco. Okay, someone's saying class administrator. Oh, thanks, Tim. Yes, I just noted Tim said yes, he can sue for that loss. Okay, so rules. Well, we know what the rules are. So it'll be Section 18 ACL. It will be, is it a representation? It may be a Section 4 issue in terms of future matter, mightn't it? Or is it just a fact? I don't know. This is my intention. This is why I require this money. This is the purpose of my loan. Stated purpose. I think it's a Section 4 issue. Okay. There's no particular case that I know of that's quite similar to this, so then we'll just use the normal culprits. It's not a normal consumer, so we don't have to worry about our reasonable person. We don't really have, it's not a class, so we don't have to worry about reasonable class. We don't have to worry about our lovely morning star moron in a hurry test. So then you'd go through and you'd say, so here, section 18 of the ACL states that both Rocco Proprietary Limited and Maria Limited are companies. Maria, as the representative, satisfies the requirement that person okay. What are we going to say, Feg? I'm sorry. Onus by plaintiff to prove either fraud or negligence were any statements and actions intended to become part of the express terms. Tim, in order to found an action on Section 18, do the statements need to become part of the express terms of the contract? We need to clear this up because this is fairly fundamental. Misrepresentation at common law is a vitiating factor. That means that the misrepresentation necessarily usually happens prior to entry of the contract. Is the ACL any different, Tim? Anyone want to jump in? Can you not recover under the ACL if the representation was made before a contract was formed? ACL hits after the contract has been formed. Well, thank you, Diane. It doesn't matter when the misrepresentation was made, does it? It just says it has to lead you into error. It has to mislead. And this is the beauty of Section 18. It doesn't matter if it misleads you into a contract, whether it misleads you into, for my purposes in terms of IP law, it doesn't matter that it misleads people into thinking that you are a licensed, a licensee of a trademark, that you have authority to trade under that trademark. It can mislead you into almost anything. That's the beauty of the ACL. It just kind of stops. You mustn't mislead. And us as lawyers are all going, mislead how? You know, contract? What area of law are you talking about? But it's sufficient that someone's misleading people. It could be you know, misleading in terms of trademark law. It could mean that you've mistaken one person's product on the supermarket shelf for another. Okay, so it doesn't matter that it gets incorporated into a contract or not, because the misleading is not tied to contract law in any way. So Maria had intentions to induce Rocco to enter the contract. you need to prove inducement and reliance. You need to prove reliance here, but we need to get over element 2 first, Tim. So, trade or commerce. And I know that there are people out there that know the case name. Oh, Melissa, the clouds opened and the angels sang. Look at this. I'm just going to copy and paste your words. Concrete constructions. That is the case you need to know. The other one I would take there for our $25 Jeopardy is recurring guy. That's another case that commonly gets cited in terms of trade or commerce. Okay. It's a very broad term that means anything, basically anything with a commercial flavour. So here, the transaction was a business loan. This would satisfy the requirement of trade or commerce. Yep. Conduct. Engage. In conduct. What is the conduct that's involved here? As to the purpose of a business loan. Have I stated that sufficiently? Element 4, mislead. Now, before we can discuss that, we need to talk about, okay, does this fall into section 4? Let's go and have a wee look here. Okay. Person makes a representation with respect to any future matter. This is kind of mean doing it right now, isn't it? You're also sick of this stuff. No! Leave me alone. Section 4. Go away. Person doesn't have reasonable grounds. It's taken to be misleading. Taken to be misleading. So, if Maria states the conduct will be taken to be misleading. Okay, we don't know. There's not enough facts in here to tell us whether she definitively had reasonable grounds. Is there really? I'll just flip back here. She says she's going to require further funds to establish a supply chain infrastructure. It sounds legit, doesn't it? But then she just goes and blows it all. I guess there's not enough really there, is there, for us to make any informed, you know, you'd have to say what were the negotiations like, you know, what did she supply you with any documents that showed, you know, why she needed this figure of $30,000. You'd have to ask for some further questions, wouldn't you, really, I think, to provide any kind of decent advice. Yes, Tim's saying Tim would crucify Maria already. He's saying that you can infer that she doesn't have reasonable grounds because of her, you know, all of the items that she bought, the personal items that she bought. Maybe she was the one that won the $100 million Powerball the other day. Dang! posting or exploits on Facebook showed proof. Yeah. I'm not sure on the, was there anything referred to in the loan agreement? Well, that's a good point. Whether there's, I mean, generally speaking, loans, they'll specify a purpose, but they won't necessarily go into like all of the reasons why they want that figure, which would be the reasonable grounds, wouldn't they? But that's a good point. You'd want to have a look at the loan contract as well. I think, you know, we need to know whether there was any evidence apart from the purchase personal items which may suggest, is that how we want to put it? That she didn't. If it's for a business loan, it could possibly be argued, yes. I think it all really comes down to what would come out in the negotiations there. You know, how much evidence. I need 30 grand because I need, you know, 22 grand for a new vehicle. I need, do you know what I mean? I need another 3,000 for this and 5,000 for that. Rocco could have set up a 30 grand trust. Yes, he could. Tim, are you doing equity this term? I love it. The creativity of lawyers never ceases to amaze me. Okay, so
can't you dodge 4B? Sorry, can't you dodge section 4 if you can show that you're not making a representation about the future? You're making a representation about the current state of mind.
Yes.
That's smashing carpets.
If you are making a representation as to a present state of mind, then you are straight into that murky area that I was talking about before, where Cheshire and Fivefoot is having this war of words. You know, they're not really, but their view is slightly different to Wilmot's view in relation to whether or not you need to prove recklessness. You know, even if you don't have to go through the Section 4 presumption, if you had to show recklessness anyway, I mean, it's not a whole lot different to Section 4 in my view. Section 4 says you've got to show reasonable grounds, which to me says, well, if you've got reasonable grounds for making a statement, then you're not making it recklessly. Do you know what I mean? It tends to suggest. So I think it's a distinction without a difference almost. Kind of get their knickers in a twist about this stuff quite often when, you know, sometimes I think all roads lead to the same conclusion. Anyway, assuming that she could. So the Section 18, it's definitely conduct. So we need to come back to whether it's misleading. Campbell. Well, you know, he certainly wouldn't have entered into that loan agreement if he knew that it was for just anything other than the stated purpose, I think. So, assuming that he can establish so, remedies. Let's have a look here. What is the provision? I'm going to make everyone car sick again and do my scrolling. What provision am I looking for? I'm spinning the wheel, spinning the wheel. Woohoo! Thanks, Diane. 237. I love these provisions. Love, love, love. Love, 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 love. Okay. 236 is your damages, right? That's just plain, boring old damages. 237 is the funky stuff, right? And I wanted to take you here because the way it works is a little bit convoluted, right? So it says, a court may, on application of a person, the injured person, who suffered or is likely to suffer loss or damage because of the conduct of another person, and it contravened Section 18, or it can be the ACCC, obviously. Then you can make such order or orders as the court thinks appropriate against the naughty person or a person involved. Aha. Who's that then? So we could go, we could sue Maria's company and we could join. Yes, Diane's saying Maria personally, absolutely, as a person involved. So if we look at, I wonder if that's going to take me there. Some of these links don't work. No. Okay. Person involved is anyone that aids, abets, counsels or procures a breach, or is knowingly, directly or indirectly involved in a breach. That would be Maria, obviously. So we could join her to our action. And then it says, okay, you can get such orders as the court thinks appropriate. How you're thinking? Well, the orders are suggested, included in 243. So then you've got to truck on down to 243, kinds of orders that might be made. I love this stuff. Look, an order declaring, and this is obviously inclusive, not exhaustive, whole or any part of a contract to be void. So you can have partial voidness. You can have either void ab initio or void only on and after such date. So void, but it's kind of got the effect of a termination. Can you see? Because it's just chopping the contract off at this particular date and leaving the rest on foot. That's pretty sweet. Variations or variations only on and after such date. Can you see how flexible this stuff is? It's like create your own cake. Refusal to enforce, refunds, return of property, directing the respondent to pay the amount of, let me just move this over here, the loss or damage, if you're looking under 239.1. Repair or provide parts. How can she repay? She spent the 30, how can she repay? Good point, Tim, we'll come back to that. An order directing the respondent to supply services, creating an interest in land. Can you see how broad that stuff is? It's incredibly broad. So that is the beauty of 237 married up with 243. So these are generally called compensatory orders. Yes, you can get, where are we? Yeah, there we go. You can get a refund of your money here, but these orders are generally called compensatory orders, and they are linked up with 237. So as I said, 236 is just your straight damages. 237 are your compensatory orders. But it doesn't stop there. You have injunctions. You have the ones that I really like. There we go. An order requiring, this is under a slightly different provision here. So where the regulator takes action instead of the person that suffered loss, check this out. An order, this is like name and shame stuff. Requiring the person to publish an advertisement in such terms as specified in the order. How scary is that? I am a naughty offender. An order requiring a person who's made false representations to make available a training video. Isn't this great? I think this is just a grab bag of goodies. And this is why the ACO is so much fun to work with. Because there's just an inordinate amount of flexibility, particularly in the 237, 243 kind of stuff, that, it's just not accessible at common law. The courts must have just been jumping with glee when this legislation hit the books in 74. So, jumping back, we have the potential for Section 237 compensatory order, possibly declaring the contract void from a certain date, if necessary. I just say ab initio. There's a lot of stuff that she can get. Now, under 237, generally speaking, under Henville and Walker, what is your measure for damages usually? What is your measure for damages usually? Is it the contractual measure or the tortious measure? Shame. Darren Hinch stuff. Yes, it's Tim's just said on the chat. It's the tortious measure. So, although the CCH case, now that was a breach of, was a breach of Section 18. That was actually an interesting copyright case. You had a software developer that warranted that they had the right to license, to assign copyright to one company, and then the company licensed that software that it thought it owned the rights to one of its subsidiaries. And it actually turned out that the person that assigned the copyright didn't have the right to do so. And so the subsidiary on the end was not a valid licensee. And so what did CCH do in the end? They sued, didn't they, under Section 18? And they sued, interestingly, for the misrepresentation that was made to their head company. And they got up. This is the power of Section 18. So, and there they actually breach of Section 18. I'll just put here copyright. I can put the citation in there for you later on when I put stuff. The contractual measure. You don't really know. Generally speaking, as Wilmot says, you will probably get the tortious measure. So the tortious measure means what? Why am I putting exclamation marks there? Second civil matter. Not sure what you're getting at there, Tim. Why am I so excited about the contractual measure of damages being used? How is that different to the tortious measure?
I don't know.
Well, breach of contract, yes, Keith has got it. It's the expectation loss. So breach of contract damages will normally try and get you into the position that you would be in as if the contract had gone to plan. So to get you the profits and the expectation that you would have gained from the bargain. Torts just aims to compensate you and get you back to the same position as if the tort hadn't happened. it's potentially a much lower figure. Okay. Now, there is one mention in Wilmot about times where you can look at potentially getting something. This is in the context of their discussion about the tortious measure. I wonder if that'll correct. Ooh, where okay. So this is where I said you would probably be claiming for rescission, return of your 30 grand, and potentially the $8,000 loss that he now has to bear by virtue of buying that cutlery other than at the discounted rate. Yes? So there's my thoughts there. Now, Tim very, in an anticipatory move there, has said, well, that's all very well, but what if she's already spent the 30 grand? That is all very well. And what if she has already spent the 30 grand? Where are we at then? Do we just let it go? No, let it go. Let it go.
Can't the court make an order, and then if she doesn't comply with that order, then they can apply for bankruptcy?
You could.
As an extreme.
Execution of execution of the order. So you don't have to push her that way, but there's all sorts of sneaky stuff that they can do. You'll learn that in civil procedure if you haven't already. You know, they can send bailiffs around and seize goods and whatnot. And wouldn't that be a pleasant job? No, don't take my children's television. Does that make a little bit more sense? I'm hoping that tonight has shown you that there is an endless amount of use that you can make of the ACL, and it's not just law school stuff, it's quite practical. Any questions? Take my children. Any questions about that, peeps? Questions? No? Okay. Good. Let me stop sharing. Let me see all your beautiful faces again. All right. Thanks to all the peeps at home. I am going to stop.